Well, good afternoon, everybody. Thank you so much for joining us. Sorry we're getting started just a couple minutes late, but I'm thrilled that you took the time to come out and have this discussion. And it is going to be a discussion because what I've asked Mike and David to do, we're all going to sort of talk for maybe 4 or 5 minutes each, give a little bit of perspective on the issue, which I will summarize in a moment. But then take questions, take ideas, toss some ideas around. The point of this really is to do two things. One, there has been a lot of activity in the Congress in the last really kind of 6 to 9 months around the concern that a lot of Americans expressed when Edward Snowden began to reveal some of the programs that the NSA and the intelligence community were using to gather information globally, but most concerningly on Americans and their interactions. There was initially quite a bit of uncertainty, and you know, I was spending a lot of time reassuring people that the FBI is not listening to your phone calls, that the IC is gathering, the intelligence community is gathering metadata. So there was a process of making sure that kind of people understood what was actually happening. But then there was a great deal of discomfort with the nature of those programs as people came to understand them. And by the way, that's not the unanimous position. I listen to my constituents hard on this issue, and that's sort of the point of today's meeting, amongst others. Some people are in the camp of, hey, you know, capture the list of folks I'm calling. If it helps keep me safer, that's fine with me. Some people are very much in another camp, which is government has no business gathering this information. So I'm delighted to be joined by David McGuire, who is General Counsel of Connecticut ACLU.
Staff Attorney.
Staff Attorney at the Connecticut American branch of the American Civil Liberties Union. We're also joined by Mike German, who was 13 years in the FBI?
16.
16 years in the FBI and is now with the Brennan Center for Justice and spends most of his time thinking about and writing about this issue of where we draw the line on questions of surveillance. And so thank you, gentlemen, for joining. I am going to try to be somewhat disciplined in keeping us all to, you know, kind of 15 minutes or so that we can have a discussion. It's important to me as your representative to know how you feel about these issues and as I formulate my own position. Those of you who follow how I vote on these things, you will know a couple of things. I have generally been in the camp of those who over time have developed discomfort with the extent of surveillance of the American people. And I use the language fairly carefully because I get a lot of statements like, for example, the metadata collection program is clearly a usurpation of the Constitution and just downright illegal. It's not. Federal court judges have ruled in opposite directions as to the legality of the program. And I'm talking now about the metadata program. And the legality is, as a non-lawyer, ambiguous. That could change if Congress were to finally pass some legislation on the issue. I will tell you that I came out after some deliberation, not basing my opinion on legal history or questions of law, but came out with just a visceral discomfort over the metadata collection program. I can't put it any more simply than to say that in a free society, the idea that a Central Security Service gathers that much data on every American just makes me viscerally uncomfortable, particularly when I've spent a lot of time looking at the efficacy of this program in actually stopping terrorist attacks, and that is very much an open question. The answer is not zero, but it's also not what we were led to believe at first, that this is a very valuable program in stopping terrorist attacks. I don't want to spend too much more time on that. Oh, and by the way, that turned into my supporting a bill that passed 2 weeks ago in the Congress, the USA Freedom Act, which we will talk more about because the USA Freedom Act of today is not the USA Freedom Act of 6 months ago, and there were some adjustments made. But just so you know where I come out on this. There are other issues that I would like to draw out a little bit today that are not necessarily privacy and constitution and legal in nature. Edward Snowden's revelations have created a real problem for our high-tech industry. If you talk to somebody who makes technological equipment, the servers and the equipment that runs our networks, they will tell you that they're having a hard time selling that equipment abroad because of the concern that the NSA may have backdoors on equipment, that sort of thing. Regardless of what you think of the legal issues here, that's a very serious issue for a very important and competitive American industry and not one that is easily addressed. You have a third issue, which I hope we talk a little bit about, which is, in some ways, the metadata collection program, this is, and I didn't start by saying what it is of course the program whereby the NSA captures my phone number when it calls your phone number and the duration of that call. That's not the only program that is out there, and we have this body of privacy law that was created in the era of copper-wired telephone calls that doesn't really fit very comfortably over today's technological world. Bizarrely, in my opinion, the rules for what happens over a copper telephone wire are different than the rules that govern an email that I send to you or that you send to me. That's obviously a bit odd. And so that's a third topic. How do we sort of revamp our rules and regulations to reflect the fact that very few of us are communicating via the old copper wires that we all used 20 or 30 years ago. So those are the issues that I hope we can touch on. Why don't I now, in keeping with the discipline I was hoping I could do, turn to David McGuire for 5 minutes or so, and then we'll come to Mike German. And again, thank you, gentlemen, for joining us, and thank you all very much for being here.
Thank you for having me. As Representative Heim said, I'm David McGuire from the Connecticut branch of the American Civil Liberties Union, and I'm going to more specifically focus on some issues of domestic surveillance in Connecticut. The work that Representative Himes is doing in Washington is driving policy reform at the state level, and there are some real threats at the state level that I'd like to make everyone aware of. The first two are areas that are completely unregulated. The first is drones, which is something that you've probably heard about on the news or read in the newspaper. The Connecticut General Assembly struggled with a drone bill this last session. Ultimately, no compromise was reached. And this is a time-sensitive issue in that the FAA is expected to largely deregulate federal airspace next year. So states are trying to play catch up and get some regulations in place before this technology proliferates. The second is license plate readers. You may have read about these as well. Similar to some issues at the national level, what we find here is that large amounts of data are being collected on largely innocent citizens and civilians. In Connecticut, for example, we've identified 24 departments that are actively collecting and sharing this data. They have a database of somewhere in the neighborhood of 8 to 10 million scans. So again, the push from Washington to rein in and have easily discernible, concrete standards about what can be collected and how long it can be stored are important in driving our state reform as well. And then the one that it most closely tracks the issues that Representative Himes is working on is a particular statute in Connecticut that's called the ex parte cell phone statute. And this is a statute that passed in 2005 in the wake of 9/11. This statute allows police departments and prosecutors to not only get your metadata, but also get the historical or real-time information of where your phone has been. So as you all know, when you have a cell phone on, it's constantly pulling off towers and creating a record of where you've been. In Connecticut, the law has the same standard as Section 215 of the Patriot Act. That's a relevant and material, that is relevant material to an ongoing investigation. And this relaxed standard has never resulted in the denial of an order in Connecticut. So since 2005, every one of these orders that has been applied for has been granted on something much less than a probable cause warrant. Unlike the problem that we have in Washington, there is some transparency in Connecticut in that the state's attorney has to put out a report on how many of these orders are granted each year. Last year in Connecticut, 1,800 of these orders were issued. And we are looking to Washington again in this respect to try to motivate state legislators to really put some thought into these issues, listen to their constituents, and get things done. As far as the work that Representative Himes and others are doing down in Washington, we believe that it's a great first step. That things do need to be shored up a bit at the Senate, but what the House did was make a clear statement that indiscriminate bulk surveillance is not okay. And I'll turn it over to Mike, who knows a lot more about the specifics of the Washington bill, and I'm happy to answer any questions later.
Thanks, David. Mike?
Thank you, Congressman, for having me. Thank you all for coming. My approach on this subject of surveillance comes from having been an FBI agent for 16 years and actually worked undercover. So I understand the need for a certain level of government secrecy, but I think we have to be very careful to make sure we keep in mind that that secrecy is actually very dangerous to our democracy. And while it's necessary in certain limited circumstances and for a limited amount of time, when that secrecy becomes something that can blanket entire programs for a decade or more, it's very threatening to our ability to maintain democratic control of the institutions that in name are out there to defend our national security. But when there isn't appropriate public oversight, often they can stray from that somewhat ambiguously defined mission. And typically what we see are sort of the same groups being targeted: new immigrants, people of color, and most particularly people who dissent from government policies or protest against government policies. And of course, we've seen that over and over again as the rules have been relaxed since 9/11. And I think on the one hand, it's great that we can have this debate now from a more informed place because of Edward Snowden's leaks, but it's really another sign of the problems that you have an informed insider who has no other way to bring to the public's attention these programs, absent risking his own freedom, and perhaps by not being able to narrowly categorize the information he's provided in these circumstances, perhaps risking more. So I think what we need to do is make sure that we have strong whistleblower protections, number one, especially coming from the community, and knowing how difficult it is to dissent from within, to make sure that those people who have conscientious objections to U.S. policies have a way to do that and report that to the responsible committees, but also to all their members of Congress and eventually to the public. Because as we've seen in this debate, once the public is fully informed of the scope of these problems, it's a lot easier for them to weigh in with their representatives, and that's how our robust democracy works. And I think as Americans, we have a right to know the scope of these programs, particularly where they impact Americans. So thanks again for having this debate.
Yeah, thank you. And thank you, David, for bringing in some issues that are, I think, in some cases more relevant to people's day-to-day lives. We actually see the police cars with the readers on the back more often than I think we come across the NSA. 2 minutes now just on kind of where Washington has gone and where it may or may not go. Those of you who have followed this closely know that about a year ago or so, when Edward Snowden began to release these programs, there was, of course, a furor, and there was a period of time when people were struggling to understand the nature of some of the programs that were discussed. The White House and others have sort of tagged along and tried to provide some clarity on the nature of these programs, which were highly classified before Snowden leaked them. And there has been a legislative response that is not done yet. And just to very quickly summarize that legislative response, right out of the box, we saw my colleague Justin Amash of Michigan remarkably. Now, Justin is, I think, a freshman. We're pretty different politically. I'm a Democrat. He's probably as far to the right in the libertarian camp as there is in the Congress. He put an amendment on the floor that would have just flat out ended metadata collection programs, and it almost passed. And it frankly shocked the leadership that it had that much support. I actually voted against the Amash amendment because I sit on the Intelligence Committee, and it was a procedural thing more than anything else. Justin, with all due respect, not sitting on the committees of jurisdiction, didn't really know what they were, and I'm a big fan of understanding the value of these programs and getting behind the law and this, that, and the other thing. It morphed ultimately into a bill called the USA Freedom Act, which also would have cut off bulk collection of data on American citizens. It then passed the House of Representatives in a USA Freedom Act, which I referred to earlier, which did a couple of things. It ended bulk collection programs probably. And I put an asterisk on there because at the last minute, the administration asked that some definitions be put into the restriction on gathering in bulk information that introduced a little bit of ambiguity. And so critics of the bill, and they're fair critics, say, wait a second, the definition would allow you just need to be specific about what you're collecting. So the NSA could, in theory, say, if the legal interpretation permitted, that we'd like to get phone calls from everybody in Chicago. That's the charge. There is a guard on that in that any ruling that a judge of the Foreign Intelligence Surveillance Court makes on this must be declassified and told to us publicly. In other words, if they were to rule that you could ask for all the phone call metadata in Chicago, we would know about it. Well, that maybe makes you, depending on where you sit on this, somewhat more or less comfortable. There was also some modifications made to the NSA. One, this was my amendment in the Intel authorization bill, would introduce a Senate-confirmed, presidentially appointed Inspector General within the NSA. They don't have one right now. Right now, that Inspector General in the NSA is in the chain of command. That's an uncomfortable fact, at least in my opinion. And there were other changes made, including the introduction of what's known as an amicus, somebody who, under certain circumstances, could argue in front of the FISA court. This is the secret court that approves requests for programs or warrants by the FBI, by the NSA, whoever it may be. But of course, they do it in secret because this is, asking for warrants on potential terrorists. There would be introduced an adversary, although an adversary is not quite the same as an amicus, who would argue in favor of civil liberties in that courtroom. Right now, that courtroom is the government saying to a judge, we would like to do this. And nobody other than the judge's discretion saying, actually, no, that's not a good idea because X, Y, Z. Just to conclude, those bills passed the House of Representatives and now await action in the Senate. Now, in the Senate, on the leadership, you've got Dianne Feinstein and Saxby Chambliss, both of whom are pretty, I would say, in my opinion, fairly they lean into the national security side of things. And so it's sort of an open question as to where these ideas go. I happen to believe that this summer the Senate will probably take up this bill, and it will be worth watching very closely because in the Senate it's kind of interesting. Chambliss and Dianne Feinstein are maybe in the national security camp, but you've got some very aggressive senators. I would point to Ron Wyden and Mark Udall and others who are very much more on the civil liberty side of things. So you're going to see, I think, probably quite an interesting kind of legislative fight in the Senate. So with that, let me open it up to folks who may. We've touched on a lot of different topics. Questions, observations. If you simply want to state your opinion, that's fine too. Let me, Paul, how are we? Do you have a microphone set up on it? Yeah. Let me, just for order's sake, if you have a comment or an observation, why don't we ask folks to line up over here at the microphone, and I'll just ask people to kind of limit their questions or comments to a minute or two, so that we get everybody who might be interested. The mic is actually, you can use electric, I suppose, too, but.
Yeah.
Scene one, scene the ball.
Yeah.
My name is Robert Boyard, and I was fortunate enough to sit right next to the microphone. Congressman Hines, recognizing that your security clearance is a lot higher than us citizens here, and privy to a lot of what's going on, or certainly more than we are, and your hesitancy to fall clearly on one side or the other, to me is, it's clear that this is a complex issue. And I think of how the government, its role is to protect its citizenry at one point. I remember in 9/11, right after hearing about 9/11, the total freak out for all of us. And what that felt like emotionally, let alone intellectually. And I know that there are people who are afraid that will happen again. I'm in a place where I don't have an answer. I mean, I'm not simply going one side or the other on this thing in any way, shape, or form. But my sense is that as you have more knowledge than we do, is it possible for you to share with us kind of what the two camps are and why it is at the top line anyhow that there are these two camps? You mentioned Dianne Feinstein. I was living in San Francisco in the late 70s when she was assistant mayor and Harvey Milk and whatever were shot. So I would think she's got a sort of a visceral sense of what terrorism in its own way, and I have no idea whether that affects her psychologically or not. But if you can give us a sense overall of what the two camps are, that'd be helpful.
Sure, and if I wasn't clear on kind of where I came out on this, I try to do my work, but I tried to be clear. You know, having spent some time thinking about it and really studying it, I came out in opposition of bulk collection on U.S. citizens. And again, I tried to explain this before. I don't root that in legality or constitutionality. I root it in just something a little visceral about a Central Security Service gathering that kind of information. So I oppose it, and that was part of the reason I supported USA Freedom, and am concerned about some of the linguistic flexibility in the House version of USA Freedom. But you asked me to describe the two camps, and I can't describe them any better than I sort of did before, which is those folks who say, look, it doesn't bother me that, and by the way, my constituents are roughly split on this. I polled it in a poll I did some time ago. They're roughly split between those who say it doesn't matter to me if the government gets essentially the information that's on my phone bill, if it helps keep us safe. And those who, in the other camp, ACLU would be an organization that represents probably that camp pretty well, which just says, that's not acceptable. We have to abide by the standards. I personally sort of apply two tests to this. One is is it constitutional and legal? And if that question is ambiguous, then I need to know, is it effective? And that's actually an important question to ask. There's a very big difference between a marginal program. Let's maybe agree, and I'm sure some people in the room disagree with this, but let's agree that the bulk metadata collection program is somewhere in the world of legally ambiguous. Then the question has got to be, is it useful? And the fact is, after months of questioning, the government could kind of kick up one or two examples where it wasn't even essential to use that bulk metadata, but maybe it helped. And so I think that has to be the line of reasoning. But anyway, you asked about the two camps. There are those who say, hey, it doesn't trouble me. And those who say, no, it really does trouble me that the government is doing this stuff. And by the way, I have to ask a third question, or maybe look at it from a different standpoint. This will annoy some people in the room, but I've spent a lot of time around FBI agents and NSA people and CIA people, and they're pretty easy to draw a cartoon around, these sort of ominous agencies that do something in secret. I have never met anybody in any of those agencies who isn't pretty serious about operating within the bounds of the law. There may be there, but they have general counsel's office, the attorney general takes it seriously, and yet that isn't always the case. So we had an example. In fact, our current FBI director was a real hero because he stood up in a different administration when John Ashcroft was in a hospital bed and the Bush administration was doing out-and-out warrantless wiretapping, and Comey said, I am not going to move forward with this thing that the Oval Office has commanded me to do. So you also have to ask the question about, even if you trust the current gang, what about the next one? And I think that's a really important test, because administrations will ebb and flow based on their respect for constitutional strictures.
Hi, my name is Abraham Smith. Thank you for holding this forum. One thing you mentioned about the foreign intelligence surveillance courts was that you made this kind of slight comment that, well, of course, there's terrorism involved, so we have to have some degree of secrecy. But I've never really understood why this traditional, court, judge, warrant system we have isn't sufficient for this. Why do we need a secret court, whether or not it has an amicus system, to deal with these cases? We've always had a court system that's dealt with all sorts of very subtle things, organized crime and so forth. What's different about this?
Do you want to take a whack at that?
Sure. And I think that's a great question. And, I did undercover work in domestic terrorism groups and used criminal justice techniques that were constitutionally tested in court. My sources and methods were revealed in court, and yet I would turn around after one case was finished and go back undercover using the same sources and methods just as effectively. And I think you're exactly right that these methods that are tried and true for a reason, because they are effective. And to the people who would say, well, I don't care if the government collects my records, I would just answer, if you're not a terrorist or a criminal, the government collecting your records doesn't improve security, right? And I think that's, and I appreciate the Congressman saying this, that typically when you see the government targeting people who aren't actual threats, that's wasted effort. Those are resources that should be directed towards real threats. And the system that we have to do that are the evidentiary levels of reasonable suspicion, probable cause, those things that are built in to our constitutional system. With the, half of the amendments in the Constitution are to limit the government's police powers, because our founders recognized that that is where the government can most easily err to the worst effect on our liberty. So we want to make sure that those protections are kept. On the intelligence side of the house, there are very few protections. And I worked in the intelligence community for 16 years, and I share the Congressman's assessment that this is mostly people who are trying very hard to do their jobs in an appropriate manner and within the law. But when your job is to protect the nation, it's very natural to become overzealous. And unfortunately, what we've seen time and time again is that overzealousness leads to overreach, particularly where there are some inherent biases. And when I worked at the ACLU in DC, we exposed a lot of FBI training programs that were very anti-Muslim, anti-Arab, but also identified political activity as terrorism. So this is part of the problem, that we want to make sure that we have the public oversight necessary to make sure that these agencies are properly directed and effective, because all of this effort going into something that isn't effective, we have a 12, 13-year-long program collecting our metadata that now we find out wasn't ever really that effective. We could have avoided that privacy violation and not lost anything in the way of security.
Right. Well, regardless of the forum that it's heard in, like Representative Himes states, there really needs to be some unambiguous definitions, and that specific selection term is a big one. It's one that if that is defined properly, that will make sure that it's used effectively. And like both other panelists, I have no doubt that most security agents want to keep the country safe, and they're doing this in the spirit of public safety. At the same time, unfortunately, Ed Snowden's revelations have shown that the NSA has a tendency to adopt a broader interpretation to try to get the information they believe they need to keep us safe. So I think if the Senate does sit down and think about specific selection term and come up with the right definition that works, it does not handicap security but also make sure it's used properly, then the forum becomes less of an issue.
The interest, to come back to the question very quickly, the interest that we do have, I think, is in preserving the safety of sources and methods, and that's a fancy way of saying if we can get information that is valuable from a national security standpoint, we don't want the avenue by which we get that information to be known to terrorists, because they'll stop using that avenue. That requires some degree. So, for example, the FISA court, most of their business is the FBI going to them and saying, we'd like to put a wiretap on this individual. That's most of what they do. Individuals, maybe email addresses, but they also do programs. So the FISA court ruled a number of times on the metadata collection program. I would offer up maybe that the standard of approval has to be that much more comprehensive and maybe public in some instances, preserving sources and methods when you're talking about programs rather than just individuals, because I think individuals are analogous. I mean, we don't tell suspects of the mafia in a purely domestic context when the FBI gets a wiretap authority on them, and so I think the analogy applies pretty well there. But there is an inherent problem there in that the more that the quote-unquote bad guys know about our sources and methods, the less valuable those sources and methods are. If there was somebody from the CIA or NSA sitting here right now, I think that's probably the argument they would articulate. Yes, Sal.
Hi, Jim. I just have one question. Are you of the view, Secretary Kerry's and President Obama's view, of Edward Snowden coming back and facing criminal prosecution at an anti-violence panel? Everybody can answer that question, so.
Guess we're all going to give our opinion here, if you want to. I'm probably the one guy that has to give an opinion.
I'll always start that way and come that way.
I mean, clearly, the information Edward Snowden provided has created a debate in this country that's long overdue. And I would hope that that would be recognized in trying to work out any particular solution to it, that there is a public benefit from the American people knowing what activities their government is conducting, perhaps to their detriment.
And let me say, Sal, I will recognize that Snowden's contention that this debate, which is important for this democracy, would not have occurred but for what he did. And I'll acknowledge that that's probably true. And that is where my affirmative and positive statements about Edward Snowden will end. This idea that he's some kind of hero is just plain wrong. There is a method by which you do civil disobedience if you feel that the laws are wrong, and that method is very clear. You break the law, and then you willingly accept the consequences for having done so. This guy, and by the way, the metadata collection program that we're talking about here is a tiny, tiny fraction of the information that he took to Russia and to China. The vast bulk of the information that he took is actually stuff that will get people killed if ever, God forbid, we're in trouble, you know, if we're in a conflict with the Chinese or the Russians, because it was military protocols, communications. He took all of that stuff, and we have no idea where it is. And it could very well be in the hands of people that we might have to, hopefully not, but fight someday. And he fled. And by the way, this great statement he made about his stance on civil liberties, he made from two of the most oppressive regimes on the planet. So he can perhaps redeem himself by getting back to this path of civil disobedience and saying, "Hey, you know, I broke the law, and I'm gonna bear the consequences for having done so." So, you know, I wish it hadn't happened. I'm glad that we are, as a democracy, having the discussion. He catalyzed it, but it can't possibly be the method by which we want to have these discussions. To have a disaffected guy in his mid-20s do what he did.
Well, from my perspective, the Snowden situation shows that we need more transparency to make sure that the rules are followed. I'm not condoning the method that he did it, but it did, like Representative Himes say, spark a debate that really needs to be heard and thought through. So I just think it's another call for transparency.
Allison Rivard, I wonder if you could express how your assessments are impacted, if at all, by reports in the media and expression of government concern that there are more persons, particularly young persons with U.S. citizenship, who have gone overseas, are going overseas to fight jihad, to, you know, become caught up in this, and that there will be more of those persons who are trained in jihad coming back into the United States, and they are U.S. citizens.
You know, I have a lot of experience working terrorist groups born and raised right here. You know, there are myriad threats to this country, and it's particularly criminal threats. You know, a third of the murders in the United States continue to go unsolved. Almost 60% of the rapes in the United States go unsolved. And yet there are 400,000 rape kits sitting in crime labs, not being processed because the police say they don't have resources. You know, part of what I think a comprehensive examination of the intelligence community will do is look at all the threats that are presented. You know, in 2008, for the first time, the Director of National Intelligence testified that the #1 threat to the United States national security was the global economy meltdown in 2007. Right? That was entirely predictable. And if our intelligence community was looking at all threats instead of one particular threat, they might have been able to mitigate that in a way that would have helped a lot more Americans than the way it turned out. So, you know, I think part of what we have to do is go back and say, you know, what are our national security interests? Where is community security part of what we're talking about, and that security should be more than just physical security, but looking at all the different things that we need to do to make sure that our country's investing in our people.
This will be an important question, hopefully less so for the United States than for some countries. Syria, as we're now seeing in Iraq, has turned into a training ground for radical jihadists. And the U.S. Persons, as they say in the law, who are there are subject to the protections of the United States Constitution. I don't think that's a bad thing. I actually believe in the U.S. Constitution. I believe that suspects and others should be protected by our Bill of Rights. The answer, of course, is not to dial back the civil liberty protections that we give to Americans who make very bad choices and go and fight in Syria or get trained. The answer, of course, is to find ways to tone down those conflicts. We're going to be faced as a country, maybe as early as tomorrow, with a question about do we want to get involved, and if so, how, in the mess in Iraq. And while you may be tempted to think this is really in the short term about are we buttressing Maliki's regime in Iraq, one of our long-term goals has got to be to calm those areas and to get them governed again so that they don't become training schools for, I mean, not just U.S., but British and Canadian and Moroccan and Egyptian and Libyan people to learn how to build explosives and how to do the things that would destabilize our own societies.
Dick Lowenstein, I have a couple of comments. I want to talk about metadata. As a citizen, I'm more concerned about the commercial use of metadata because at least the government has an interest in protecting the country. Corporations have an interest in raising money and making money. And I'm more concerned how that money, how that data is being used than I am really about how the government is using it. With respect to metadata, with all the data mining and artificial intelligence around, the mass collection of data really can be very useful if the proper artificial intelligence is applied to it and patterns observed when you otherwise would not see them. So I feel that is, at that level anyway, it's very helpful for the government and everybody else. I agree 100% with Jim's comments on Ed Snowden. This is almost a throwaway line, but one of my disappointments was the ACLU taking such a strong position in favor of Snowden. And I sometimes think the ACLU forgets that his first name is American and not anything else.
Well, I appreciate those comments. Just to be clear, not to distance myself, but the ACLU of Connecticut is a separate affiliate. So we have our own governance structure and make our decisions about our cases. So the thing that I can tell you that's kind of related to your issue is about the license plate readers, the automated license plate readers I mentioned before. A couple of the last legislative sessions, we had bills that would seek to rein in how long that data can be kept and whether it could be shared. Because right now, as I said, we know of approximately 24 departments, some in Fairfield County, that are sharing these license plate scans to tell where you've been, really to a very, very particular level. One of the really concerning pieces to this is that there are multiple distributors that sell these devices and the software that goes with them. And some of the contracts require that the private company get access to those scans. So essentially it knows where your license plate was over many, many points. And that data has been, is being used sometimes for commercial purposes. So like you said, there's a real danger in that getting out of government control. So that's something that we're trying to rein in here in Connecticut. I don't know how much of that translates to the metadata held by national security groups, but it is a real problem at home.
Any perspective on that?
Sure, and part of the problem with the excessive secrecy is, we have private companies collecting information, which, as you point out, is a big problem for American privacy, and then we have the government collecting information, which is a big problem when there isn't proper oversight. But when those two marry, that becomes very dangerous. And when those agreements are happening in secret, again, that sort of overzealousness and that imperative of national security tends to drive a lot of this stuff without a lot of forethinking about the consequences. And I think when the Congressman mentioned the economic impact that the tech industry is facing now, that should have weighed in the deliberations of, do we really need this program? But unfortunately, in those closed rooms, too often those long-term problems, much like the greater problems we're seeing around the world, right? Senator Feinstein and Representative Mike Rogers, chairman of the House Intelligence Committee this winter, said the terrorism threat today is more significant than it was on September 10th, 2001. So here we've invested all this treasure, we've invested these agencies with so much power to secretly collect information about us, and we're no safer, according to them. I mean, that should be very troubling to all of us, that we really have to have an understanding of what it is these agencies are doing to determine whether they're being effective and whether they're actually forwarding American values around the world and creating a safer environment for all of us.
2 points very quickly. Coming from somebody on the Intelligence Committee, this statement, it was almost a political statement that we're no safer than we were on September 10th. And I know Mike's not owning that statement, but that's that's really not quite accurate. The damage that was done to the institution and organization known as Al-Qaeda was profound, absolutely profound. The rate, and by the way, this poses some very tough questions about drone activity, but the rate at which the United States has been able to eliminate very senior members of organized global Al-Qaeda has been stunning. What has happened, of course, is that you've taken a vertical organization and hammered it so hard that it is fragmented. And in some ways, I don't know if that's worse or better. In some ways, it's worse in the sense that if they're fragmented in caves, they're a lot harder to find. They're also a lot less capable institutionally, which sort of comes back to addressing some of the root causes of this. But I also don't want to entirely, point number two, I don't want to entirely lose the question. I'm not sure any of us up here are expert in the commercial use of the data, and yet that is maybe not quite as frightening as the prospect of, or you articulated it, Dick, as more frightening, but it's a different thing in which I think the law is going to need to be rethought because the world has changed so dramatically. Now, with data mining and other things, I can, if I'm a marketer with good access to data, whether it's credit card data or other data, I can probably reconstruct your day yesterday. And that 50 years ago, that was inconceivable. Maybe you could find, somebody's credit card purchase records, but now you can probably, using third-party commercial data, reconstruct somebody's day. And how do we feel about that, and what do we do to stop it? Those are questions I ask a little bit beyond the scope of this discussion, but they're profound. Sarah?
Hi, Sarah Levin. I've been following these issues for quite a long time, as you probably know, and part of the reason is because my late father was a non-official cover in the CIA, and Jack Devine, who's going to be speaking in Sanford at the Ferguson next week, is a former spy master, and yesterday wrote this whole column about telling his kids how he was in the CIA, which I remember that exact conversation. But he also wrote a column saying how Snowden was exactly the kind of person they would have recruited. And what I'm finding really problematic about the response of the intelligence community to Snowden is that I didn't see this kind of response when a non-official cover CIA person was outed under Bush. From that same, in fact, I read the book by Rizzo, who was the legal counsel of the CIA during that period, and he totally minimized the damage that was done from that. So what I'm seeing is hypocrisy, and everyone from the president on down has admitted that we would not be having this very essential conversation that Ron Wyden has been warning about for years. And Udall, they all were warning. If the American public knew what was going on, they would be well, they didn't say freaking out, but they said it, in not my language. But they said, basically, that they would be totally freaking out. And you see, now that we know what was going on, we are freaking out. Or at least 50% of us, according to you, are freaking out. So, the fact that I find it troubling that you are so, Snowden is a traitor, but the people who released Valerie Plane's name are not traitors, and that that Clapper can go to Congress and lie about this and not be a traitor. I just find this, it just seems a little bit conflicting views to me. So I just wonder if you can speak to that.
Yeah, I didn't say anything about Valerie Plame. I gave my opinion on Edward Snowden. Valerie Plame, if I recall correctly, Scooter Libby was prosecuted and convicted, ultimately pardoned by. Right, and I don't support. So I don't. You're trying to set me up as having a double standard. I don't think that's.
I'm not saying you. I'm saying the intelligence community in general. A lot of the same people in the intelligence community who are saying that Snowden should, is a traitor and should be hung from the highest rooftop, like Jack Devine, who's speaking next week. Are, we're minimizing when the same thing happened in a different circumstance. And as the child of a non-official cover CIA person, I find that very troubling. It shows how political these agencies can be.
So I've never heard anybody at, I can't speak to Jack Devine, but I've never heard anybody at those agencies right now say that it was okay for Scooter Libby to out Valerie Plame, but what Snowden did. Now, maybe you know something I don't, but you know.
Maybe if you read Rizzo's book, he totally minimizes what was done to Valerie Plame.
No, that's a very serious breach. I mean, these officers maintain relationships with people abroad who, when it turns out that they're officers, they can be killed, and maybe were in the Valerie Plame case. So it's I don't actually draw any particular distinction myself anyway between I mean, obviously very different things, data versus, but nonetheless both were very, very serious breaches of information. And in the case of, maybe one distinction to be drawn was that Plame was outed for purely political motives, to discredit her husband, who, as you know, was challenging the Bush administration on weapons of mass destruction, whereas you know, Snowden, as misguided as I think he actually was trying to start a conversation.
So then why shouldn't Cheney have been hung? Why weren't the intelligence agencies saying that Cheney should be hung from the highest rooftop? That's what I'm saying. There's a lot of hypocrisy around.
Well, I think, first of all, I think you probably don't want to talk. It would be utterly inappropriate for anybody at an intelligence agency to say that anybody should be hung for the rooftops, right?
They're doing it now. They're doing it now.
It may be that retired agents, look, as an overseer, if anybody who was presently senior at the NSA or at the CIA or at the FBI said that Valerie Plame was okay, but look, I would be after their job, right? It's not appropriate. They are agents of the United States government. Now, when they retire, I don't know what it is that they say. But look, both, in my own opinion, both are very, very serious breaches. They're very different breaches, but they're both very serious breaches. Maybe you need to talk to Mr. Rizzo or whatever, because I agree with you. They're both very serious breaches of national security, at least with Edward Snowden. And again, this is how I started my opinion on Edward Snowden. It's hard not to give him the benefit of acknowledging that he at least catalyzed a discussion, which at the end of the day I think is going to be healthy for our democracy. The Valerie Plame thing was just nothing but rank politics.
I think you do raise a very important point, though, about classified information is leaked every day officially, and to influence policy. And those are approved leaks that all have the same security problems as these other leaks, but those don't get prosecuted. And this administration has prosecuted more Americans for revealing classified information to the press and to the American public as Espionage Act violations, as spies, as if they were handing the information over to the Russians, than all previous administrations combined. And we have recently come out of the intelligence community a directive that is intended to even clamp down further on intelligence community members even speaking to the press about unclassified matters. So, we have to make sure that our system of democracy survives this national security emergency, and that access to the public needs access to information about what its government is doing. And particularly, it's bad enough when the government isn't coming out providing us the information we need, but when they're actually providing false information, that should be punished just as much as any other violation of the law.
Do we have a few more here? I can't tell.
Rosemary Halstead. Assuming, and it sounds like there will be some legislation coming out of Washington, at least on this subject in the near future. Whatever results in terms of the breadth and scope of what the NSA and the other agencies might be allowed to do, how does that, just as a point of curiosity, how does that compare to what is currently going on in other countries, whether they be our allies or not, or others?
Yeah, that's a great question, and it's actually something worth bearing in mind. And sometimes senior people at the intelligence community do point out that start with two categories of countries. You've got one category of countries whose security services run rampant, well outside any version of anybody's law. These are whatever, China, or an awful lot of countries, unfortunately, where the security services are simply not constrained by law. And then you have countries where they are constrained by law. We are on the spectrum, and I'll turn to people who probably have thought more internationally than we have, but relative, for example, to the UK, where there's an Official Secrets Act, relative to a lot of our NATO partners, our security services are subject to much more oversight and legal restrictions than most. There are probably countries where there are more, but anyway, I'm going to turn. Would you agree with that characterization? Because
Certainly. I mean, I think that the amount of money and effort that we put into it probably dwarfs most other countries. That's so true. Even though we have probably more laws than most countries, certainly the scope of the spying that we're doing far exceeds what most countries would even be capable of. So, you know, I certainly would hope that our intelligence community is not looking to the more repressive regimes as examples of what they should emulate. You know, we want to make sure that American values are preserved both here and abroad, so that we're relying on open and transparent relations with other countries in order to make sure that the rule of law is safe for everyone.
That's a great point. To help you understand the magnitude of our activities, the actual intelligence budget is classified, but it's in the neighborhood of $70 or $80 billion. To put that into context for you, the nation of China spends $100 billion on its national security. So we're spending almost what China does on its national security, on our intelligence. Forget about the $600 billion Department of Defense budget. And one of the challenges, this is one I feel acutely, and I don't entirely know what to do about it. We have laws, and we have inspector generals, and we have the intelligence community reporting to the Department of Justice, and then we have congressional oversight in which I'm engaged. But that is a very challenged process. Think about it. There are, 21 of us or something on the House Intelligence Committee overseeing a $70 or $80 billion operation, a massive operation that is very, very technical, and in which the reports come in by the bushel. Literally, I mean, 500, 600 pages a day come into our committees saying, okay, well, here's what we're doing in this program, here's what we're doing in that program. The staffs may look at it. I don't look at 500 or 600 pages a day. It's just not physically possible. And by the time I finally get my feet on the ground and really come to understand the programs and the agencies and whatnot, I'm term limited on the committee. So, you know, people are on average 6 years or so on the committee. So just as you're getting to a point where you can ask the tough questions, you're back to Ways and Means or the Appropriations Committee or whatever. And again, I have never seen an example, with the possible exception of Clapper, where you could say this guy lied. But it also, the lawyers in the room will know it's all in the nature of the question you ask. And the intelligence community, in virtue of the way they think and what they do, are pretty good at being very specific about answering the question you asked, even though it's very clear that you're trying to get at something larger. There's this great scene in West Wing where they're training the West Wing TV show, where they're training the president's wife to be deposed on something very serious, and the counsel says to her, do you know what time it is? And she says, yeah, it's 3:30. No, he says, no, do you know what time it is? It's 3:30. No, do you know what time it is? And it dawns on her, and she says, yes. And that's the kind of challenge. Russ?
Jim, good to see you. Your comment about being challenged on the Intelligence Committee is sort of dovetails with the topic that I want you to address. Sarah had started to touch on some of it in one direction. I'd like to touch on it in a different direction. Democracies are not the only countries that have needed to have intelligence agencies. And we can all think of instances where countries that have, let's say, some sort of reputation historically in the past for doing some pretty nasty things based on and using intelligence agencies. Recognizing it with all due respect to the FBI, when we look back on our own history, and we have the FBI essentially targeting a guy like Martin Luther King, who was completely peaceful protester. And today, when we have young people, sitting down on the ground, on their hands, protesting peacefully, and they are harassed, accosted physically, pepper sprayed, and yet a group of people with automatic weapons in Nevada See you tomorrow. Have a good day. I'm not trying to point out the politics of this stuff. I'm using it to get towards the points I really want you to address, and that is a previous administration had made a point about they'd made some decisions about foreign policy, which we're having to pay the price for right now. And that same administration had the insight to look into Putin's eyes. We all know that that didn't work out too well. I mean, about looking into Putin's eyes. I don't really think we feel comfortable looking into the eyes of Putin's counterparts here. I think what we need is a rule of law, not of individuals. It shouldn't be based simply on, I know this guy is a good guy. I'm sure he's a good guy. But that's really beside the point. And the problem that you have, that you yourself just said before I took the mic, is an issue. When you have a secret court and double secret policies and organizations and individuals, and the only oversight is this group in Congress, and they are lied to, how is it that that person, and I have nothing against the guy personally, so I'm not recommending an action, but how is it possible that if that's our only oversight and he can come lie, that he's still there? How is it that you, and I'm trying to raise your own awareness, and I want to hear your own responses. How is it that you can say, this is a good group of guys, but we don't know what the next group of guys is going to be? Well, it's got to be procedural. It's got to be legal. And there has to be some transparency with the public in order for this not to spiral in some negative direction. So I've thrown a lot of disparate ideas, but the focus really gets to how is it that the voting public gets to have their say about all this stuff if we never are allowed to hear the truth, and the people that are running these programs are allowed to lie to the only people that do get to hear the truth.
Yeah, Russ, I appreciate where you're coming from, and look, you articulated the reason we're all here today, and the reason this is a really hard conversation, which is that to be effective, some of what the intelligence community does has to be done in secret, and in virtue of it being done in secret, it can't be scrutinized in the context of our democratic discussion. Sarah made reference to Ron Wyden, I guess, who knew about these programs, that he suspected people would be pretty upset about, but he couldn't say it would have been a violation of the law for him to. Although I always wondered whether the administration would prosecute a senator for making public something that he felt was problematic. But you put your finger on a really tough issue. Now, and look, I do want to bound this. Look, you say when people lie. In the year I've been paying close attention to this, Clapper's statement, which was just out and out false, was the one I can think of. And he defends himself by saying that it was the least wrong answer I could give, which I think is just baloney. He should have said, Senator, we're not going to talk about this in this room. Full stop. And, oh gosh, maybe that would have pointed to, at least in the general direction of a program. But that, to me, pointing in the general direction of a program is a much better outcome than having the situation where a member of the executive lies to the Congress, which is unacceptable. But I guess I would observe that in my own time there, this is not a systemic thing. This is something that he has done. I worry, frankly, much more about the complexity and the difficulty for a layperson like myself getting into the technology. And if I can get my head into the technology, now I got to get my head into Fourth Amendment law and Maryland v. Smith. And I mean, I really have to work hard to get my head around one little program, much less the hundreds. So oversight is really challenging, and it's not what it should be. By the way, we're human beings. And as human beings, when you spend a lot of time in a closed room with somebody else, you know, you develop a certain affinity. So now all of a sudden you're giving that individual the benefit of the doubt. And I got to tell you, if oversight is about one thing, it's about not giving the benefit of the doubt. So there are some very powerful forces working against effective oversight. I don't know.
So Jim, just to very good points. I would simply come back at you a little bit with, if it's ineffective now, I'm not going to use that word, but if it falls short right now, let's say, of where it should be, then isn't it the job of the people in your position, you and your colleagues, to change it so that you can do your job more effectively?
Absolutely. Yeah. No question about that. Yeah.
So what time is it?
Well, I mean, here's why we're having this conversation.
And if I could just add, I mean, we also have FISA court opinions from 2009 and again in 2011 where the intelligence community came clean about having misled the court in getting approvals for these programs, both the metadata program and the content program of Section 702. So, you know, clearly there is this problem of, you know, and not necessarily in some, you know, horrible intentional way, but, you know, you have 5 million cleared people now working in this enterprise, and the people at the top don't necessarily have the correct information about how the programs are actually being implemented. But I think you raise a good point, because we have to remember, you know, this secret intelligence enterprise that we have is still a fairly modern creation, right? This is post-World War II. And it was first examined in the 1970s with the Church and Pike committees. And you know, these systems that we have now, the intelligence committees in Congress and the foreign intelligence surveillance courts, were sort of experiments, right? This is a way that we want to try to regulate this enterprise that has these potential problems. And what the Church Committee warned about is the next national security emergency. And they said, you know, we'll recommend that you create this, but you have to be vigilant when there's an emergency to make sure that the system is still capable of working. And I think what we have now is at least some evidence that another calibration needs to be made. And I think a comprehensive examination of what this enterprise is doing, whether it's meeting the mission effectively, and whether it's doing so in compliance with the law and our constitutional rights.
Yes, ma'am. Thank you, Russ.
Louisa Vancourt, I was wondering if political money is playing any part or affecting the discussion and the whole program that's going on with all the breakdown of campaign finance law.
That's a great question. By and large, not much. And by the way, I say that happily because political money influences so much of what happens, but partly because the big names, and just to be fair, let's just use George Soros on one side and Shelley Adelson on the other, you know, are no more privy to some of the confidential stuff that we deal with than anybody else is. There is an industry, an intelligence community of the size that I outlined earlier, of course, has a lot of people making stuff for it, and those people who are making that stuff want to continue to make stuff, and that's where I actually see it. You'd be surprised by how many of my colleagues, and I will also not hold myself above this tendency, are real supporters of the technology that is made in their state or their district. But you know, this is also something that's very analogous to what we see in the defense budget, which is one of the big reasons I voted against the National Defense Authorization Bill. So yes, does that happen? It happens a little bit, but it happens in a way at a much smaller level than, you know, if I weren't a supporter of the Black Hawk helicopter, there would be headlines about the 15,000 jobs in, you know, southwestern Connecticut. That almost by definition couldn't happen in the intelligence budget, but it does happen to some extent. Yes. John, did you?
Jim, before we go, could we do a straw vote to see who's on which camp?
Sure, but what would we be? I want to ask good questions in order to get good data.
who's on the side of the NSA and who's on the side of the anti-NSA. I think it's a legitimate question. You said there are two camps, and you said that the district is split.
No. That's look. I'm not going to ask that question. I just the premise. Look, I will ask the question of how many people are comfortable with collection of telephony metadata. But look, this isn't a ball game, right? I mean, I'm not going to ask for an opinion on the NSA. But I will ask. But is that an okay question? So the question is, the first question will be, how many people would support NSA bulk metadata collection? That's capturing not the substance, but the number that calls the number and the length of the time. And question number two is, how many people oppose it? So the question is, how many people support that program and would be okay with it continuing? Okay, I see about 7 hands. How many people oppose that? Okay, well, the nays have it.
Jim, one final question? I have it.
Oh, yeah.
One final question. For the purposes of full disclosure, my name is Ian Dow. I'm a doctoral candidate at St. John's University. I'm a human rights historian, member of the ACLU. But I also think that I stand for the vast silent majority of Americans who don't necessarily stand on the on the bleeding right or on the blue, but rather purple kind of in between, so to speak. And I just wanted to ask, is there any, and I wanted to get comments from all three of you gentlemen regarding this. Do you think that there is any plausible and reasonable way or mechanism that you can think of that would take away some of the ambiguity regarding the FISA courts and the FISA courts and the laws regarding intelligence gathering, etc., without harming our national intelligence capabilities and our ability to gather pertinent and relevant information that could potentially harm our government? I'll leave that with you, gentlemen. Thank you.
Do you want to start?
If we had the answer to that one, I think we'd be in great shape. I mean, like I said earlier, I really do think transparency is the absolute key here in terms of getting more of the FISA opinions out there, so that the public and watchdog groups can hold, national security agencies accountable when they are taking liberties and going beyond the scope of the powers that are before them. There's not really a great solution for all of this. I mean, I think having the amicus to present this civil liberties issue is a good thing. But the biggest thing is that this conversation continues and does not end if and when the USA Freedom Act passes. That's the biggest fear that I have, that a good first step is taken, but there's not the follow-through. And people need to remain vigilant and contact their senators and their representatives and continue to ask hard questions.
And I would agree that it's about transparency. I mean, when the Obama administration took over, they agreed to do a review of the FISA court opinions to see what could be released, and ultimately said that the facts of each case were so intricately entwined within the legal reasoning that they couldn't be publicly released. Well, now that we've seen them, we see that's not true. And these were just interpretations of law that Americans, if there's one thing in this country that should, we can dispute what sources and methods need to be protected, but the law should never be secret, particularly where it affects Americans' rights.
Yeah, and I agree with that by and large. We can and I think will take steps to make the FISA court more transparent and more worthy of our confidence. I think the introduction of an adversary or an amicus in that court is an important thing, and it's uncomfortable in as much as you're not going to be able to go watch that amicus do their thing, but just knowing it's there ought to be good. And then on questions of law as opposed to questions of fact, if you've ever read a legal opinion, it's got lots of facts and it's then got an interpretation of the law. The interpretation of the law, by and large, will not reveal sources and methods. So a lot more of the FISA court releasing how they're interpreting the law. Let me give you an example. It's not the FISA court, but one of the controversies that we had in this country still have was when the president targeted an American citizen in Yemen. Ultimately, the president released a what was known as a white paper outlining what he believed was his legal authority to target a U.S. citizen abroad, and it didn't disclose any methods or put anybody at risk, but you were able to read the president's logic, and that can come, I think, out of the FISA court. And I agree, the transparency up to the point of making sure that transparency doesn't disclose sources and methods is very important, and an ongoing debate. Russ, this takes us back to your question. Sitting on the committee as I do, there's kind of three categories of programs. You got the ones that Snowden has put out there that we're debating and talking about that used to live in category number 2, which is category of secret programs that you don't know about. And there's some of those. There's some of those, frankly, that put me in Wyden's position, where I sort of think to myself, ugh, this feels a little weird to me. And it's my job to poke at it and understand it. But then there's an awful lot that we are talking about, and the Aulaki example is a good one. How do we feel? How do we feel about, and by the way, a lot of those are ambiguous, legally ambiguous, right? I mean, we all have strong feelings, but the president maintains, as a constitutional lawyer before he did this for a living, he maintains that his going after Aulaki was a legally permissible thing. I'm not a lawyer. I have an opinion on that, but the metadata collection program, the use of unmanned aerial vehicles, we talked a little bit about drones. I guess my point is that there actually is a fair amount of stuff that we do get to talk about. And I'm not saying, therefore, that we should have less transparency over here, but it is important that we keep talking about the stuff that we do know about, and which is not secret. Because, look, Justin Amash, I told you the story of Justin Amash. His was a response to an upwelling of national outrage. Evidence of the fact that the House of Representatives, to some extent, does what it's supposed to do. Reflect the upwellings of ideas and emotions that come out of the. So anyway, I guess I'm going to close exactly where I started, because I see it's 4:15, and just say that I really appreciate the very, very good questions, the participation, especially David and Mike coming from afar to join us here, and thank you very much for participating in this conversation.